Good day and welcome to Macklaw. I'm Rian van Wyk, a jurist and a legal enthusiastic, and as you can see, today I'm flying solo. This week we'll be discussing a very important topic. We'll be discussing human dignity and very relatively to assisted suicide, or better known as euthanasia. Alright, so first off, what is human dignity? Human dignity, as envisaged by our Constitution, the little great book which we make reference to every week on Macklaw, is both a right, as envisaged in Section 10 of our Constitution, but it's also a value in which every other right is valued against. Alright? So today we will specifically be practically looking at how the courts use human dignity as a value in interpreting the right to life, and whether or not the state's duty to protecting the right to life is absolutely limitless. Alright? So in doing so, we have to make reference to case law. In 2015, a South African citizen called Mr. Stransham Ford made application to the High Court saying that, listen guys, I'm terminally ill, I'm going to die, and every day that I wait for my death, I'm suffering this immense pain that no toothache or finger amputation could ever come close to. And therefore, I would make application to this court to say, listen, I know that in our law, since 1970, since the eminence of the State versus Grotjohn case, where assisted suicide was actually made illegal or in contrast to our law, and therefore defining it as murder, I would like to vary that law. And therefore to say that, listen, in the cases of terminally ill patients like myself, could we then please apply that assisted suicide or euthanasia or mercy killings be made legal in order for me to live a dignified life, or to have my life dignified in terms of ending my life? Now, on the face of it, or prima facie, it seems like that is two opposing rights, human dignity and right to life in the circumstance. But when taking human dignity as a value, as opposed to a right, which is this other element, and using that value of human dignity and applying it to the right of life, the courts said that, listen, in cases like Mr. Stransham Ford's case, where he is terminally ill, he's going to die anyway, and he's suffering immensely because of this excruciating pain. In cases like that, we are going to say, listen here, it's fine to have euthanasia made legal, and therefore the doctors who gives him lethal injection will not be criminally prosecuted for murder, as the case was in South Africa. But now, what an interesting thing has transpired. Because of Mr. Stransham Ford's urgent application, he has now subsequently died 2 hours before judgment was handed down by Judge Fabricius. And because of that, the Minister of Justice, who was the respondent to the case, then said, listen guys, we cannot accept the handing down of this judgment where they said, listen, let's make it legal, because this person's life has ended 2 hours before the judgment. And as we know, it's right that legal personality ends at death. But the court correctly found, and I want to call it legal poetry, they said that, yes, legal personality does end at death. But this court also has an inherent jurisdiction to actually, and a constitutionally mandated authority to develop the common law according to the needs of society. And they said because of this importance of this matter, they're going to develop the common law and to make euthanasia or mercy killings or assisted suicide, which affects the right to life, they are going to make it legal. So now, the court then said it is wrong or irrelevant for them to say that the person's legal personality ended and therefore the judgment should be moot or irrelevant, because the court still has a duty to develop the common law, and therefore the judgment stood that euthanasia was legal. They've now appealed it to the Supreme Court of Appeal, but in my view that was a success in terms of using human dignity as a value and then interpreting it into testing the right to life's absolution. Now, last week, Mr. Mack and I had a discussion on the death penalty in our criminal justice system show. And Mr. Mack posed some very pertinent questions about the death penalty, and my view was pro-death penalty in certain circumstances, whether or not the state proved beyond a shadow of a doubt that the person was guilty. But now, the assisted suicide alleviation of its illegality has proven that human dignity as a value can be taken to take any absolute fundamental right and actually place limitations on it if it hinders someone's subjective human dignity. And that is how human dignity is used practically. Now, I just don't want to focus on these huge cases such as the right to life or assisted suicide. Human dignity can be used in any other right. It can be used in employment rights, it can be used in equity, it can be used in discriminatory suits. It can be used everywhere because it is a value that protects all fundamental rights. And I just want everybody out there to know that if you feel like your human dignity has been affected in any other way, use it as a value and go to your closest magistrate's court who has equality courts there where you can actually find justice for your human dignity, whether it pertains to the right to equality, right to life, right to freedom, right to personal security of the body, whatever the case may be. That's Macklaw. Watch us next week. We will be tackling more controversial topics.